There is an old truth in American democracy that every president eventually learns. You can command armies, you can sign executive orders, you can declare emergencies, but you cannot command the courts. And this week, Donald Trump learned that lesson in the most brutal way possible. On December 23rd, just before the Supreme Court broke for the holidays, something unprecedented happened. The Conservative majority court that Trump himself helped build, that has granted him victory after victory throughout his second term, finally said no. In a 6-3 ruling, the justices blocked Trump's deployment of National Guard troops in Illinois. It was not just a legal defeat, it was a fracture in the foundation of everything Trump believed he could do with unchecked executive power. But here is what the mainstream media is not telling you. This was not an isolated setback, it was the first domino. Because while cameras focused on the holiday ruling, a tsunami of legal defeats has been quietly building around the Trump administration. More than 358 lawsuits have been filed against Trump's executive actions. The administration has lost a staggering 199 of them. Meanwhile, courts have granted the government wins in only 110 cases. The walls are closing in, not with handcuffs, but with gavels. And the president who promised to restore law and order is discovering that the law has limits even he cannot break. Today, we are going to expose the legal war that is dismantling Trump's agenda piece by piece. We are going to show you why the Supreme Court's National Guard ruling is a ticking time bomb for his entire strategy. We are going to reveal the tariff case that has Trump posting in all caps that America is screwed if he loses. And we are going to explain why the most dangerous threat to this administration is not coming from protesters or politicians, but from the one branch of government that cannot be fired, cannot be threatened, and increasingly cannot be controlled. Welcome to The Breaking Point. To understand why the December 23rd ruling matters so much, you have to understand what Trump was trying to do in Chicago. The official story was simple. Immigration and customs enforcement agents needed protection. Protests against ICE raids had turned violent. The federal government needed to step in. So in October, Trump deployed 300 members of the National Guard, federalizing troops from both Illinois and Texas to patrol the streets of Chicago. He invoked a federal statute that allows the president to call up the Guard when he is unable with the regular forces to execute the laws of the United States. It sounded reasonable, it sounded necessary, but it was a lie. Or more precisely, it was an interpretation of the law so expansive that it would fundamentally rewrite the boundaries of presidential power. Federal District Judge April Perry saw through it immediately. In a scathing opinion, she found no credible evidence of rebellion or danger of rebellion in Chicago. She identified what she called a troubling trend of the Trump administration equating protests with riots. She noted that government officials showed both bias and lack of objectivity. The protesters were not insurrectionists. They were Americans exercising their constitutional rights. And Trump was trying to silence them with soldiers. The Seventh Circuit Court of Appeals agreed. They allowed Trump to federalize the Guard members on paper, but prohibited their actual deployment. They saw the game. Trump wanted boots on the ground, guns on display, military force used against civilians who dared to oppose his immigration policies. The court said no. So Trump took it to the Supreme Court, confident that his 3 appointed justices and the Conservative majority would give him what he wanted. They had, after all, granted him 20 emergency victories out of 24 cases in his first year back in office. The court had been his reliable backup plan, his final appeal, his insurance policy. But on December 23rd, the insurance policy expired. The Supreme Court did not just reject Trump's request, they demolished his legal reasoning. In an unsigned opinion, the majority ruled that regular forces in the statute likely refers to the regular United States military, not federal law enforcement agents. This was critical. Trump had argued that since ICE agents could not handle the protests, he could send in the National Guard. But the court said that is not how the law works. The law requires the president to show that the actual military cannot execute the law. And under another federal statute, the Posse Comitatus Act, the military is generally forbidden from conducting domestic law enforcement except in very narrow circumstances, like actual insurrections. The majority went even further. They stated that deployment of federal troops to execute the laws is exceptional, and that the government failed to identify a source of authority that would permit such action in Illinois. It was a legal evisceration. Chief Justice John Roberts, Justice Amy Coney Barrett, and Justice Brett Kavanaugh joined with the 3 Liberal justices to form the majority. 3 Conservative justices, Samuel Alito, Clarence Thomas, and Neil Gorsuch, dissented. But the message was clear. Even Trump's Supreme Court has limits. The implications are seismic. Trump had already deployed National Guard troops, not just in Illinois, but in California, Oregon, and Washington, D.C. The Illinois ruling effectively blocks all of those deployments. Federal courts in Portland and Los Angeles had already issued similar orders. Now the Supreme Court has validated their reasoning. The president who promised to send troops into American cities to restore order has been told by the highest court in the land that he does not have that power. Not under this law, not under these circumstances. But here is where it gets truly dangerous. In his concurring opinion, Justice Brett Kavanaugh dropped a hint that reads like a roadmap for Trump's next move. Kavanaugh wrote that the court's opinion does not address the president's authority under the Insurrection Act. This is the nuclear option. The Insurrection Act is a set of laws from the nation's first century that gives the president sweeping power to deploy both the National Guard and regular military forces to quell widespread unrest. It is intentionally vague. It gives the president massive discretion, and unlike the law Trump tried to use in Illinois, there are almost no judicial checks on it. Less than a month after the Supreme Court ruling, Trump began floating exactly this idea. In response to protests in Minneapolis over ICE enforcement actions, Trump posted on Truth Social that if Minnesota politicians do not stop the professional agitators and insurrectionists, he might have to invoke the Insurrection Act. It was a threat. It was also a test. Trump is asking, if the courts block one path to military force, can I just take another? Legal scholars are divided. Some argue that courts have no power to review a president's decision to invoke the Insurrection Act. The law is so broad that presidential judgment is essentially uncheckable. Others insist that courts must scrutinise whether the conditions for invocation actually exist, whether there truly is an insurrection, because otherwise the president becomes a king. This is not theoretical, this is happening in real time. And if Trump invokes the Insurrection Act, we are headed for a constitutional crisis that will make the Illinois case look like a parking dispute. While the National Guard case dominated headlines, another legal bomb is ticking toward detonation. It is the case Trump himself has called the most important case ever. It is Learning Resources Incorporated versus Trump, and it is about to decide whether Trump has the power to impose massive tariffs on the entire world without congressional approval. On April 2nd of last year, Trump declared a series of national emergencies. He declared emergencies over fentanyl flows, over trade imbalances, over perceived threats to American manufacturing. Under each emergency, he imposed sweeping tariffs on imports from dozens of countries. He used a 1977 law called the International Emergency Economic Powers Act, known as IEPA. This law gives the president special powers during genuine national emergencies, but it does not specifically authorise tariffs. Trump's legal team argued that the broad emergency powers include the ability to impose trade restrictions. Critics argued that Trump was doing an end run around Congress, which has the constitutional power to regulate commerce and set tariffs. Multiple companies sued. Lower courts ruled against Trump, finding that he had exceeded his authority. But the Supreme Court allowed the tariffs to remain in place while the case proceeded. Oral arguments were heard on November 5th, and during those arguments, both Conservative and Liberal justices asked deeply sceptical questions about Trump's interpretation of the law. They seemed unconvinced that IEEPA grants the president unilateral power to reshape global trade. They worried about creating a precedent where any future president could declare an economic emergency and rewrite trade policy overnight. Now, as of mid-January, the court has not yet issued its ruling. Every day that passes, Trump grows more anxious. He has been posting frantically on social media. On January 13th, he wrote in all capital letters, "If the Supreme Court rules against the United States of America on this national security bonanza, we're screwed." It is a remarkable admission of desperation. Trump has built his entire economic agenda around these tariffs. He claims they will pay down the national debt, fund aid to farmers, and finance what he calls a warrior dividend for service members. But the math does not work without the tariffs. And if the court rules against him, more than $100 billion in already collected tariffs could have to be refunded. The fiscal hole would be catastrophic, but the political damage would be worse. Trump has staked his credibility on being tough on China, tough on trade, tough on protecting American workers. If the Supreme Court rules that he never had the legal authority to impose his signature tariffs, it exposes him as a president operating outside the bounds of law. It makes every tariff announcement, every trade negotiation, every tough guy tweet look like bluster without legal foundation. Economists and legal experts are watching closely. Some argue that Trump could still impose tariffs using other legal authorities, like Section 232 of the Trade Expansion Act for national security concerns, or Section 301 of the Trade Act for unfair trade practices. But those authorities are narrower and require more specific justifications. They would not allow Trump to slap blanket tariffs on everything from everywhere based solely on his declaration of an emergency. If the Supreme Court strikes down the IEEPA tariffs, Trump's trade war becomes legally constrained in ways it has never been before. And that constrains his power in ways that terrify him. There is a third case that is equally explosive, but it moves on a slower fuse. It is the birthright citizenship case. On January 20th of last year, mere hours after being sworn in for his second term, Trump signed Executive Order 14160. The order declared that children born in the United States would no longer automatically receive citizenship if their parents were in the country illegally or temporarily. It was a direct assault on the 14th Amendment, which states clearly that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. The legal challenges were immediate. 18 Democratic state attorneys general sued. Civil rights organisations sued. Within days, federal judges across the country issued preliminary injunctions blocking the order from taking effect. Every single court that has reviewed the order on the merits has found it likely unconstitutional. The legal reasoning is straightforward. The Supreme Court decided this question in 1898 in United States versus Wong Kim Ark. The court held that a child born in the United States to Chinese parents with permanent residence was entitled to citizenship under the 14th Amendment. Later cases, between 1955 and 1967, repeatedly affirmed that being born on American soil makes you subject to the jurisdiction thereof, regardless of your parents' immigration status. Trump's lawyers argue that those precedents have been misread. They claim the 14th Amendment only applies to children whose parents have permanent domicile and residence in the United States. They argue that children of undocumented immigrants or temporary visa holders are not subject to the jurisdiction of the United States in the way the 14th Amendment requires. It is a creative argument. It is also, according to every legal scholar who has reviewed the issue, wrong. But Trump does not need to be right on the merits. He needs to be right with the Supreme Court. And on December 5th, the Supreme Court agreed to hear the case. Oral arguments are expected in the spring of 2026. A decision will come by late June or early July. This timing is no accident. The court deliberately delayed taking up the case on the merits. It could have ruled in the summer of 2025 when Trump first appealed. Instead, it pushed the decision into an election year. Court observers believe this delay is strategic. The court has a long history of waiting until a president's approval ratings decline before delivering major legal losses. Trump started his second term with positive approval ratings, but by December, those numbers had collapsed. An NBC News poll showed only 42% of adults approving of Trump's performance, with 58% disapproving. The court is waiting for Trump to be politically weaker before it strikes him down. If the Supreme Court rules against Trump on birthright citizenship, which most legal experts extend, the consequences extend far beyond immigration policy. It will be a definitive statement that even the most conservative Supreme Court in generations will not rewrite the Constitution to suit Trump's agenda. It will embolden lower courts to challenge him more aggressively, and it will expose the limits of judicial appointments as a political strategy. Trump appointed 3 Supreme Court justices expecting loyalty. What he is getting is law. Beyond the big 3 cases, there is a 4th that has received less attention but carries enormous implications. It is Trump's attempt to fire members of independent regulatory agencies. In his first year back in office, Trump fired or attempted to fire multiple officials, including Federal Reserve Governor Lisa Cook, Federal Trade Commission officials Rebecca Slaughter and Alvaro Bedoya, and others. His reasoning was simple. They were Democrats. Their service was inconsistent with his administration's policies. Therefore, he wanted them gone. But here is the problem. These officials serve on independent commissions that were specifically designed to be insulated from presidential control. Congress structured these agencies, including the Federal Reserve, the FTC, the Federal Communications Commission, and others, to operate independently precisely to prevent presidents from politicizing their decisions. Officials on these boards can only be fired for cause, meaning misconduct or incapacity, not political disagreement. Lower courts blocked Trump's firings. They ruled that his actions violated decades of precedent establishing the independence of these agencies. Trump appealed to the Supreme Court. Oral arguments were held on December 8th, and unlike the other cases, the conservative justices seemed sympathetic to Trump's position. They signalled they might be willing to abandon precedent and grant the president much broader removal power. But critically, they did not grant Trump immediate relief. They scheduled arguments and left the lower court orders in place, meaning Lisa Cook and other officials remain in their positions for now. This is the pattern emerging across all of Trump's legal battles. Even when the Supreme Court might eventually rule in his favour, it is not giving him immediate wins. It is making him wait, making him sweat, making him operate under legal constraints that previous presidents respected without being forced. The delay itself is a defeat, because Trump's entire governing style depends on speed, on action, on the appearance of dominance. Being told to wait is being told no. The data tells a devastating story. According to Just Security's litigation tracker, as of mid-January 2026, the Trump administration faces 253 active cases challenging its executive actions. Out of those, courts have issued 51 permanent injunctions blocking government actions, 108 temporary restraining orders or preliminary injunctions, and 33 orders blocking actions pending appeal. That is 199 cases where plaintiffs have won some form of relief against Trump's policies. The government has won outright in only 110 cases. There are still 228 cases awaiting court rulings. These are not just statistics. They are lives disrupted, policies halted, presidential power constrained. Trump is losing in court more than any president in modern history, and these losses are accelerating. In his first term, Trump faced significant legal challenges, but he also had some breathing room. Courts moved slowly. Appeals took time. By the time final rulings came down, Trump had often moved on to new policies. But in his second term, courts are acting faster and more aggressively. They see the patterns. They see the overreach. And they are not waiting to stop it. One particularly revealing case involves Trump's attempt to withhold federal transportation funds from states that refuse to cooperate with immigration enforcement. California and 21 other states sued. A federal court issued a permanent injunction blocking the policy. The Trump administration appealed. Then, on January 13th, the Justice Department filed a motion to dismiss its own appeal. They surrendered. They accepted defeat. California Attorney General Rob Bonta put it bluntly. The Trump administration attempted to use vital transportation dollars as a bargaining chip for its political agenda. That is why my fellow attorneys general and I stepped in to stop these illegal actions. I am pleased that the Trump administration has accepted defeat and agreed to drop its appeal. This is what losing looks like when you are an administration that stakes everything on projecting strength. You do not just lose the case, you lose the appeal, you lose the will to keep fighting. And then your opponent publishes a press release celebrating your surrender. There is a deeper pattern here that goes beyond individual cases. It is about the nature of executive power in American democracy. For Trump, power is personal. It flows from his will, his instinct, his decision. He sees the presidency as a position of command, where his word becomes law. He has said repeatedly that Article 2 of the Constitution gives him the power to do whatever he wants. He believes that his election mandate entitles him to reshape government however he sees fit, constrained only by political opposition, not legal limits. But American constitutional democracy was designed to frustrate exactly this kind of thinking. The founders created a system of separated powers specifically to prevent any one person from accumulating too much authority. They gave Congress the power to write laws. They gave the executive the power to enforce laws. And critically, they gave the judiciary the power to say what the law is and whether the executive is following it. These are not suggestions. They are not norms that presidents can choose to respect or ignore. They are constitutional requirements enforced by courts with the power to issue orders that even presidents must obey. Trump has spent his entire second term testing whether that system still works. He has issued executive orders at a pace never before seen, more than 160 in his first year alone. He has declared national emergencies to bypass congressional authority. He has federalized state National Guard units over governors' objections. He has attempted to fire independent agency officials. He has tried to end constitutional rights by executive decree. At every turn, he has pushed the boundaries of presidential power to their absolute limit and beyond. And at every turn, eventually, courts have said no. The question now is what happens when a president refuses to accept judicial authority. We have seen hints of this defiance. When courts blocked his immigration policies, Trump's officials have been caught not fully complying with court orders. When judges ruled against National Guard deployments, Trump responded by threatening to invoke the Insurrection Act instead. When the Supreme Court delayed his tariff victory, Trump posted that America is screwed if the court rules against him, as if the court's role is to validate his will rather than interpret the law. Legal scholars worry about a phenomenon they call the paper tiger theory of judicial authority. Courts have no armies. They cannot enforce their own orders. They rely on the executive branch to implement their rulings. Supreme Court Chief Justice John Marshall acknowledged this vulnerability in 1832, writing that the court has neither force nor will, but merely judgment. What happens if a president simply ignores that judgment? The answer is that we enter constitutional crisis. Lower courts depend on executive agencies to follow their orders. If ICE agents ignore injunctions, if Treasury officials collect tariffs that courts have declared illegal, if National Guard troops deploy despite judicial prohibitions, then the entire system of checks and balances collapses. We become a nation where law is whatever the president says it is, enforced by whatever power he commands. That is not democracy. That is authoritarianism. So far, we have not reached that point. Trump's officials have largely complied with court orders, even when they disagree with them. They have appealed rather than defied. They have sought stays rather than ignored injunctions. But the rhetoric is escalating. The threats are becoming less subtle and the patience is wearing thin. Justice Brett Kavanaugh's footnote in the Illinois National Guard case is particularly ominous in this context. Kavanaugh suggested that Trump could use the Insurrection Act if he cannot use other authorities. But he also noted that using conventional military forces instead of the National Guard could lead to the military being deployed more frequently for domestic law enforcement. In other words, the court's effort to constrain Trump's power might simply push him to use more extreme measures that are harder to constrain. This is the paradox of judicial review in the age of Trump. Courts can say no, but they cannot make Trump accept no as an answer. They can block individual policies, but they cannot stop him from trying again and again with slight variations until he finds a legal loophole that works or simply overwhelms the system with so many challenges that courts cannot keep up. They can declare his actions unconstitutional, but they cannot remove him from office. Only Congress can do that through impeachment, and only voters can do that through elections. Which brings us to the ultimate question. Why does this matter to you? If you are not involved in immigration enforcement, if you are not importing goods subject to tariffs, if you are not serving on an independent agency, why should you care about Trump's legal defeats? The answer is simple. These cases are not about Trump. They are about whether any president can be checked when they go too far. They are about whether the Constitution means what it says or what the president wants it to mean. They are about whether you live in a country governed by law or governed by one man's will. Because here is the truth. Today, Trump is using emergency powers to impose tariffs you might not even notice. Tomorrow, another president could use those same powers to seize property, restrict travel, censor speech, anything that can be justified as responding to a declared emergency. Today, Trump is deploying National Guard troops to Chicago. Tomorrow, another president could deploy them to your city based on nothing more than their assertion that it is necessary. Today, Trump is trying to strip citizenship from children born in the United States. Tomorrow, another president could strip other constitutional rights from other groups using the same logic. The courts standing up to Trump are not protecting Trump's opponents. They are protecting the system that protects all of us. They are maintaining the principle that power has limits, that rights have meaning, that law is more than the president's opinion. And that is why Trump is so desperate to win these cases. Not because losing them prevents him from governing, but because losing them proves that he is not above the law, that he is not a king, that he is a president, bound by the Constitution he swore to uphold, whether he likes it or not. The Supreme Court ruling on the National Guard was not just a legal defeat, it was a message. Even the justices Trump appointed, even the Conservative majority he helped create, even the court that has given him victory after victory, will say no when he goes too far. The tariff case that has him posting, "We're screwed," is not about trade policy. It is about whether he can declare emergencies whenever it is politically convenient and use those emergencies to bypass Congress entirely. The birthright citizenship case is not about immigration. It is about whether the 14th Amendment means what it has meant for 150 years, or whether it can be rewritten by executive order. These are the battles that will define American democracy for the next generation. And right now, the outcome is uncertain. Trump has lost key battles, but the war is not over. The court has not yet ruled on tariffs. They have not yet ruled on birthright citizenship. They have not yet decided how far they will go to constrain a president who believes constraints do not apply to him. What we know is this. The emergency court order that hit Trump on December 23rd was the first major crack in his armour. It showed that even his Supreme Court has limits. It demonstrated that judicial independence still exists, and it proved that no president, no matter how popular they were with their base or how many justices they appointed, can simply do whatever they want.